For the $3 driveway. Not like he was doing fast. Anyway, flip the old truck, septic truck.
The septic tank, yeah.
Yeah, the old.
Welcome, everybody, to the Committee of Adjustment for the July 3rd, 2025 meeting. Just a note that if at any point that when I call the audience to talk, you have to raise your hand and please submit your name and address so it can be added to the minutes of our meeting, okay? And one person at a time. Okay, so we'll, Jonathan's there. Do we have any declaration of pecuniary interest? No, okay. We'll move on to the adoption of the agenda.
It is moved by Rox St. Louis and seconded by Kathleen Rochon. Be it resolved that the agenda for the Committee of Adjustment meeting held on July 3rd, 2025 be adopted as presented.
Everybody's good? All right. We'll move on to the adoption of the minutes, please.
It is moved by Rox St. Louis and seconded by Jonathan Sandiford. Be it resolved that the minutes of the Committee of Adjustment meeting held on June 10th, 2025 be adopted as presented.
Everybody had a chance to read the old minutes? Everything's okay? All right, carried. We'll move on to the applications. 5.1, number 1, C29/25, Northland Farm.
Thank you. It is moved by Rox St. Louis and seconded by Kathleen Rochon. Be it resolved that the consent application made by Northland Farms and Contracting for the creation of 2 new lots at 216 Rainbow Road, Municipality of West Nipissing is approved on the following conditions. That a reference plan be prepared and deposited in the Land Registry Office and a copy of the new survey be filed with the municipality. Confirmation that all property taxes are paid to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice of the consent shall be deemed not to have been given. That a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. In the event that any portion of a municipally maintained and traveled road be located on either the severed or retained lands, that 10 meters from the center line of the maintained and traveled road, including the retained lands, shall be surveyed at the owner's cost and transferred to the municipality, and that the municipal clerk shall, pursuant to Section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for the drainage maintenance among the parts into which the lands are being divided. So through you, Mr. Chair, I'll just pull up the application here very quickly. This is an application that is a resubmission of a file. It was approved in 2023 initially, and that application unfortunately did lapse. So they're coming back in, applying for the exact same situation again. You can see on your screen here, sorry, that's a bit small. It is a fairly significantly sized lot. So your retained area is almost 86 hectares. Your severed one is 8 hectares with about 170 meters of frontage. And your second severed lot is 1 hectare with your minimum 61 meters of frontage. You do have a letter which was received from Madeline Beaudry from the West Nipissing Federation of Agriculture. That is in the separate package that's not included in your agenda. And her main concerns were asking if the municipal drain was considered and if this property was tile drained. And I will leave it with that for any questions or comments.
Okay, any comment from our panel? Go ahead, Kathleen.
Do we have confirmation as to whether the areas for proposed severance are tile drained?
If I may pass that to the applicant.
Yeah, okay.
I believe a portion of the northerly section of Severed 1 was tile drained, but a lot of it is rock and bush as well, so it's a little bit of a mixture of both, but there are fields at the north end.
Okay. Does that answer your question?
Yes, it does. Thank you.
Okay. Any more questions? Okay, any questions from the audience?
What? Okay,
Olivier?
yeah, Daniel Olivier, 694 Olivier Road in Runner. Okay, to you, Mr. Chair. I'm going to object to the first one. I don't want to be disrespectful to this body. I just want to leave. Been at it 12 hours. I want to go and have supper too. I got two things I'd like to talk about. And I know I was here last month, so I won't reiterate what I said last month. It's the same principle again. I'm one of the person that did that map 20 years ago in 2004, agricultural map. And I could see, I don't know how many of those are very agricultural. I just got the package, I didn't look. But what I said last month is that there would be an avalanche coming of those. And what really irritates me is the 25% tax rate. When you have farmland, we're paying 25%, a quarter of the tax rate for the assessment because it's farmland. So it's hard for me to see a mockery that's coming for this thing. If you're paying the 25% tax rate, you're claiming farmland, and then all of a sudden you're claiming it's not farmland. Like, at the end of the day, some of the taxpayer around here has to pick up that 25% that we're not paying on farmland. But I, being a full-time farmer, I'm really in favor of that 25%. We've got the documentation to support why that is. But if you cannot be talking on both sides of your mouth, claiming it's for 20 years or 10 years you claim the tax rate. All of a sudden, oh, we want to do a building lot. Now it's not farmland, it's rural. Well, I was hoping we could delay that until somebody has a combination of both. 25% tax rate and also farm drainage. If we paid farm drainage $500 an acre to farm to drain that, it is farmland. So I'd like to know, how can we go from one body of claiming not to be farmland when it's time to pay taxes, claiming to be farmland when it's time to pay taxes, and not being farmland when you can't benefit from it or do a different severance. Like I said last month, I got no problem with severing, and the first one you mentioned, there's a rock outcrop. If there's a rock outcrop on the side of the road where you can build, I got no problem with that. We're not anti-development. I'm not anti-development. That's not the case. But I want to bring back to the 25%. If you have claimed that for the last 10, 15 years, and we, to be able to claim it, Madeleine will be speaking after on, we have to be members of the OFA, an organization. We have to prove the government to get that farmer's number. It doesn't drop out of the sky. You have to claim that you're really, on your income tax, you're claiming farming. Firstly, so much of an income to make it worthwhile. And this is how the system works. So I'll just leave it at that. I told you it'd be too short, 3 minutes at the max. That's basically it. Farmland, the 25% is really claiming it. And this tile drainage, that's a different ballgame. But if there's a rock outcrop and you put a house, I got no problem with that. Okay?
Thank you.
Very much.
I'm Omer Laverne. I'm the Vice President of the Ontario Federation of Agriculture. Don't have a problem. I do understand there's a part that's all rock and all that. But by removing the rock and stuff like that, and if a new farmer comes, which we got a lot of hobby farmer coming to start, we are forcing them, if they buy that property in the future, we're forcing a new owner to build in the field. And her field or land, that style drain, we're going to get, because he's building a barn or a house, we're going to get less and less field. And I'm representing the agriculture to try to save our farmland because there's less and less. And the other scenario, when you put a house beside a farm and you get, it happened to me, you get some people that move and they build a house and then you cannot spread manure, you cannot go spray. And because those people, they moved and they buy a little house and it smelled shit and there's cows bawling all night, or you got a dog to protect all night or you got a donkey that hauled all night and all that. So we got to be caution over there when we put separate little land over here and bring people that building beside our agricultural land. That's it.
Thank you. Go ahead, Madame Baudry.
Madeline Baudry, Sturgeon Falls. I'm representing West Nipissing Sudbury's Federation of Agriculture. And once again, I realize that this was approved in 2023, so your rules may be different as to what you can do. I would ask again, that this be deferred back to the Ag Committee, that we look at where are the municipal drains that those tile drains are dumping into. I understand with regards to bedrock that it's not, but if the tiles beside that or the main is right beside that, it could affect the tile drainage in that field. A good example is my farm. My farm is long and narrow. Outlets were hard to achieve in the tile drainage. So one of my main outlets, it actually drains about 3/4 of a mile long. So if I do anything within that section, I'm undoing all the tile drainage because I'm affecting the main tile drain. So that's one thing. The other thing is when we tile drained, then it's done through the Heritage Fund, Northern Ontario Heritage Fund, and there is a 5-year lien on the property. It does not distinguish between rock and cultivation land. The lien is on the whole property. So I think when we're doing this, we need to make sure, how are we affecting municipal drains? Was it done on a tile drainage grant? Is there still a lien on that property because of that? The other thing is 2 years ago when they brought this forward, we were working on the present OP. We know that right now there's a new OP that is in the process of being done, as I stipulated a month ago. The more we fragment these lands, then what is the purpose of the new OP? I'm kind of losing it. So if we're not cautious in what we do at this point, the new OP is going to be eventually approved and half of it won't be valid when it comes to the ag lands. So I think that that's something we want to look at. And the actions done here could severely compromise long-term agriculture viability and make it more difficult for future policies to achieve the intended effect. So I think that even though you are working on the OP present today, you still have to consider that future OP also. And I think that as we look at it again, I'll stipulate again, in Nipissing District, we have 62,102 acres in cultivation. It is a $16 million cash receipts. So it is something to pay attention to. I'm not saying no, I'm saying defer to your ag committee, let them look at all those factors and make a recommendation because it is ag land.
Thank you. Any questions? I would like, Samantha, can we see it on Google Map? Just to see the if there's the outcrop and where there's the farmland on it. With the severed is, the other one isn't.
So you've got a proposed severed lot, this 8 hectare, and then this 1 hectare out of
Okay.
here. So you're looking at a small lot in this corner here, and then likely to align about the same size on this far side.
Okay, thank you.
Sorry, Ms. Willett, the red portion is the retained portion, correct?
Sorry, the red is the existing lot.
Oh, okay, okay.
Okay. Any more questions from our panel? Go ahead, Kathleen.
So both of the lots that are proposed are actually over active fields that are actively in agricultural production.
Yes.
Okay. I
Or
just
no? Not all of it?
I don't think this portion is.
Go ahead with your question.
okay. You know, when I was doing the reading for, preparing for this meeting, I kind of looked up some resources on Committee of Adjustment and the things that we should be taking into consideration. And one of the things is conformity with provincial policies. And we know that the provincial policy statement from October of 2024 does put a great focus on the preservation of agricultural lands. I have often said that agriculture is our most important economic sector within the municipality. And some of the other things they listed was the conservation and protection of natural resources. And agriculture is considered a natural resource because it is something that generates wealth for our citizens from the earth, and also the impact upon current and future uses of surrounding properties. And so, you know, I kind of have the same fears shared by some of the audience members that we're going to see so many applications to pull 2 acres here and 4 acres here and 10 acres here out of our agricultural land stocks between now and whenever the new official plan is passed, that it could have great impact. It's going to be a rush to get these things done, and I think that the intent of the provincial planning statement is clear. And, you know, again, you know, when you're looking at non-viable lands, you know, the calculation is a little different. But if you're looking at lands that are tiled, that are actually farmable, arable land, I do have some concerns. Thank you.
Thank you. Anything else from, okay,
So for myself, I struggle a bit with this. I understand everything about the agricultural portion and all that, and I don't know why they want to sever. It didn't come to me. However, if I'm the owner of that land and I want to sever a portion because my son is going to build a house right beside me and he's going to help me farm that land and help produce more, and that kind of thought process. And again, I'm just speculating because I have no idea why they want to sever a portion of that land. For me personally, I think that would be a fantastic idea because my family comes from a farm in Verner, and my grandfather gave my uncle a portion of the land, so he was able, and my other uncle was on the other side. So as a family, they were able to farm that land, right? I don't know if that's the intent for this, by no means. However, that's where I struggle with saying no to any development whatsoever. And I do understand, I mean, a person might come in and build a house on the 8 hectare and they're going to farm that land. It doesn't mean they're not going to farm it. It doesn't mean they're going to destroy it. That's my struggle with it. But that's just my opinion. And to add, I understand what Monsieur Olivier was saying earlier about the 25% tax. But if I sell 1 hectare to an individual, well, that individual doesn't get that privilege of the 25% tax now because he's not going to be considered farmland, right? I assume, I would have to ask our tax experts there, but I would assume if he's got just the 1 hectare, now he doesn't get that benefit. The other person does continue to get that benefit from the past, but moving forward, the one person with the 1 hectare won't get that benefit. The person with the 8 hectare, if they decide to farm and they continue to farm, then, you know, I don't see it as ruining our agricultural land, especially if it's going to be to keep families together. Again, that's speculation. I don't know why, but that's just my 2 cents.
okay. Omar?
Just to your absolute, I agree with you, it's a good concern, but I just want to give you a perfect example. In Nestorville, the Gros family, I don't know if you know them, there's about 12 kids in the family. The father owned like over 500 acres. He gave a piece of lot to everybody, all the family to build. And one of the daughter, she had built a house, she was married and everything. She died of cancer. And they sold the house, they sold the property. The intent was exactly like you said, but in the future, they sold the house to a stranger, people from down south, and there's one of them that they cannot put manure. One time they cut the horn of the cattle and they call Human Society and all kind of stuff like that because those people are not used to related farm work. But I do agree with what you're saying, but that's what we gotta, when we make decisions like that, we gotta spectacular for the future, what could impact.
No, and I respect that, but my decision unfortunately, my decision will be made on the what ifs.
Yeah.
Right? Because the what if could be, what if that daughter has a son that continues to continue farming and so on, and it goes on for generations and generations, right? So, no, and I get that.
Okay, ma'am.
My name is Miriam Banning. I'm Hank Banning's daughter. We have a concern. My dad's property is right next door. Actually, all this land used to belong to my dad, that's in question. So there's a piece of property here that belongs to my dad, which is tile drained, because that whole field is tile drained. And lots were severed on the other side to other people. I don't know who they are. Then you have people coming and walking onto your land and destroying your land as well. So we have to take that into consideration as well. To me, why not just sell the whole piece of property to a farmer who's gonna farm it? That's my thought.
Thank you. Paul, you had,
Sure, well,
you go ahead, Kathleen. Okay.
My question is there currently any residential buildings? Like, is there a house anywhere on the existing lot? Is there somebody who's living there, or is it all agricultural land at this point?
All agriculture.
There's no house?
No,
Thank you.
Go ahead, Paul.
Sure. Thanks. Mr. Chair, I just made a few notes while I was listening to people speak, and I take their comments seriously. I live on a farm myself, although I'm clearly not a farmer. The property is still going to be actively farmed. It's still owned by a farmer. It's a farmer who's also a business person. The official plan, as it currently is enacted in the municipality, was the basis, and the whole point of an official plan is so that people can make informed choices as to the lands they purchase, what is available to them at that point in time. Now, we know we have a new official plan coming in. There are some proposed changes. None of those have been enacted yet. We don't know when it's going to be enacted. It could be this year, it could be next year, it could be the year after, especially by the time it receives ministerial endorsement. There have been a number of applications. We come every meeting with applications within the rural areas. Some of them involve fields, some of them are just on the rock, road in the bush. But we haven't seen like we keep hearing about this deluge of applications that are going to be coming in. We're the ones doing the applications, and frankly, we just haven't seen that yet. And perhaps it will come that way as we get closer to that magic date of the new OP. But until the new OP is adopted, everyone's assuming that what the draft versions of it is, or have been presented, are going to be what the final version is. There's no guarantee of that. The provincial policy statements, Mayor Roshan Thorne very correctly points out that there is great emphasis placed on the agricultural. There's also great emphasis placed on new lot creation and affordable housing and more housing opportunities within the municipalities. My client purchased this land on the presumption and on the assurance from the official plan, as it is currently written, that certain things were available. So that's why he was buying up farmland that may otherwise have been sold to somebody who just wanted to have a couple of horses for their daughter, sort of like I did. But by being able to sever a couple of lots off of it, it makes it commercially viable for him to be able to continue farming the balance of the land. Rock raised some good points with respect to Dan Olivier. Yes, the 25% applies to the farmer while he's farming, absolutely, and it should be that way. There should be a break. But once those lands are no longer in farm production or have been converted to a different use, then of course they're paying the full municipal tax rate. So in fact, there's a benefit to the municipality by allowing these additional lots in the rural areas as opposed to being in the ag lands. The roads are still being plowed, the school bus is going down them, the garbage truck is going down them. The municipality is paying for that and by allowing a few additional taxpayers along the road to offset those costs, there is a definite benefit to the municipality also. When Mike Harris was premier, he brought in a piece of legislation which it's called the Farm and Food Production Protection Act. And basically it addresses some of the concerns that Monsieur Laverne also brought up about, well, I can't spread manure next to them anymore. Well, that act basically says as long as the farmer is following accepted farm practices, nobody can complain and no municipality can pass a bylaw restricting their right to be able to farm the land. That was the whole point of it, because they were experiencing them more down in the southern part of the province, the yuppies moving into the farmland and then trying to get municipalities to pass bylaws to restrict what farmers could or couldn't do on their property. Harris brought in that piece of legislation. It's a great piece of legislation for basically forcing people to be able to accommodate and live together, hopefully peacefully, and that was the whole point of the legislation, was to make it clear, though, it was in support of the farm community, and as long as the farmer is following standard farm practices, there was absolutely nothing that the newcomers could do to restrict that in any political way. So I think, and these two were already approved. It just slipped past my client's had a lot going on in the last couple of years. It was an oversight on his part. He let it lapse, but these were already approved. So we're just back to reinstate what was already approved. What happens with the new OP? That's fine. When the new OP comes in, we'll definitely abide by the policies of the new OP. But right now, we should also be abiding by the rules of the OP that are in place, that people have relied upon, that have made investments in because of what the municipality put in place at the time and is still in full force and effect. So to me, it was a good application when it was first presented. It's still a good application. Yes, there is some tile drainage on the field, and the farm's got the benefit of that for many years. But not all of this land is agricultural. When you look at it on what Ms. Willett put on screen, clearly there's an awful lot of bedrock on this. These would not be viable farms in and of themselves without the opportunity to create some additional revenue by these additional lots. So it's my contention that these lands are still being farmed only because they were in the rural area. You know, and they wouldn't have been viable as agricultural lands otherwise. So anyways, thanks for the opportunity.
Paul? You wanted to say something?
Yes, if I may, Mr. Chair, just because there's been a lot of mention of the new official plan, because the draft official plan that's in the works right now has not yet been adopted, recommended, approved by our council, it is best practice that it is not considered as policy at this time. Once it gets approved by council, we will look at kind of transition policies between it getting council's adoption and adopted by MMAH. At that point, there will likely be some transition policies about considering the current one in effect and what council's direction is with the new one. But until we reach that point, that's not something that should really be a factor.
Thank you. Something new?
Yep, only for Farm and Food Protection Act. I want this committee to be aware that I can have a list prepared for you through the Ontario Federation of Agriculture. It's a wonderful act. It doesn't prevent you against civil suit. There is a farmer in Manitoulin, which is in Northern Ontario, that is almost ready to lose his farm because he spent over $50,000 on legal fees in civil court because his neighbor doesn't like when he does this and when he doesn't do this. So the act is wonderful, but it does not protect the farmer the way it's intended to.
Thank you. Okay, Kathleen?
I just have one additional question. I'm looking at the Apple Maps or Google Maps, and there also appears to be a manure pond just north of the proposed smaller lot severance on the east side. Has that been considered and measurements done for that? Is it an active manure pond? And does the lot meet the minimum distance separation on that?
Can you answer that, Paul?
To be honest, we didn't look at that again in the new one because it is a reapplication of an existing that was approved. I'm not sure, I don't have access to the screen right now to see where this potential manure pond is located. I don't know,
Okay.
Ms. Willett, does it appear on the, what you have?
Or where's the proposed? Is this where we're looking?
Oh, we're
No,
looking,
I think it's the bigger,
it's just north, it's north of Rainville Road.
You're in the right spot. The
I-
lot,
I'm looking on Apple Maps, so I'm just, it's just, you can see there's a structure there that is like it looks like what would have been a manure pond at one point. I can't confirm that because I don't visit manure pond on a regular basis, but
Is it the dark circle in the field? I wouldn't
Yep.
assume that was manure pond, but
go ahead, Don.
they're hay bales, which he's looking at. If you
Okay.
zoom in the beside the lot that's being severed, the small lot, is that where you're looking at?
no, I'm looking
House is?
north of the start of the curve on Rainville Road, so you can see there's that little, there's a clearing there, and it looks like I said, I'm just looking
Yeah.
at
The owner of the land is there. He could answer the question. Mr. Bannick.
No manure- There is no
There's no
manure.
manure.
There's no manure
Thank
pond,
you.
they say.
okay,
Thank you.
thank you.
Okay, anything new?
I have just one thing to mention and a question. The one thing to mention, lot 1,
What's your name again?
Miriam Banning, Hank's daughter. 2/3 of that lot is working land, the other third is bush. And my question is, how many times can one person sever on their property? Two? They're only allowed 2 times, exactly in an amount of time, or?
Go ahead, Don.
Well, from what we've been going through, we were doing 3, but the last few council meetings, we've been using 2 per committee of adjustment. But this is a new owner. It's not the same land.
Okay, thank you. Okay.
So is that 2, like, I sorry, I don't
If
understand.
New owner, then you can sever twice.
New owner, he can sever twice and then that's it?
Yeah.
Okay.
Any other questions? I want to bring this to a vote. Anybody in favor? Defeated. Okay, we're moving on to
Is
the,
is that one or the other or both? Sorry, there was
choose one application.
one, but there was 2 separate fees paid, one for each of the severances. Does it apply to both of the lots or just one? I think we had this discussion at the last meeting as well. We pay $750 for one lot, we pay $750 extra for the second lot. It's put on one application form because that's the way the application forms are set up. But
Okay,
it's
so
just
I'll
asking
ask,
for clarification that it applies to both lots.
so I'll ask the committee members. Is it for both or just one? Both?
Well, to me, the way the application is presented is as a singular application for two consents. So if there is a procedural issue that is coming up, then that probably needs to be addressed somewhere else. In this committee, we're presented with one application with one resolution, and we're voting on the resolution as it was put on the floor. That's just my interpretation of the procedural side of it, but.
I assume, Paul, it'd be the same for both.
Which would be the same for both, but the application forms are set up that way. It's for both the convenience of the landowners as well as for the municipality, but the fees are totally separate. So if we go with a different system, what it's going to force the landowner to do and us to do on their behalf is to submit one application for one lot, one application for the second lot. It's going to take twice as long to get through these meetings and also increase the cost to the landowner for doing the applications. So all we're asking is just confirm that it's for both, the denial is for both of the lots.
That's what I asked, yeah.
Right.
So the defeat is for both or just the one? Both? Yes.
Okay, no, just one clarification.
Okay, thank you. We'll move on to the second, please. The C30/25, Marc Saint-Jean.
It is moved by Rox St. Louis and seconded by Jonathan Sanford. Be it resolved that the consent application for a lot addition at 94 St. Jean to 64 St. Jean Road, Municipality of West Nipissing, is approved on the following conditions: that a reference plan be prepared and deposited in the Land Registry Office, and a copy of the new survey be filed with the municipality; that confirmation that all property taxes are paid up to date; that all conditions be met on or before July 4th, 2027, being 2 years from the date of the notice; that a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent; and that a PIN consolidation be registered in the Land Registry Office in order to consolidate the lot additions lands with lands to which they're being added. So through you, Mr. Chair, I'll just pull up my screen here. This application property may look a bit familiar. So last year there was a minor variance on this property, which is being added to reduce the rear yard setback, just because of the configuration of the lot. At that time, it was identified that there was an intent to purchase a land to the rear to add to the lot. So this will kind of cure that reduced rear yard setback that they asked for at that point. The retained land is quite large, as you can see on the next screen. Your retained land is easily over 60 acres here. So that's the proposal in front of you, is just that lot addition to the rear. I will note that you do have a letter from the public in that addendum package opposing the application. I will, however, note that the concerns that are identified within that letter are outside the scope of this application.
Perfect. Any questions regarding this application? Just a lot addition to the, it's from the orange to the yellow.
That is correct, yes.
Okay. No questions? Hearing none, I'll bring it to a vote. Everybody in favor? Carried. All right. Number 3, C31/25, Champagne Custom Home Builders on Bain Avenue. Go ahead.
Thank you. It is moved by Kathleen Shaw and seconded by Rox St. Louis. Be it resolved that the consent application for the creation of 2 new lots at 55 Bain, Municipality of West Nipissing, is approved on the following conditions: that a reference plan be prepared and deposited in the Land Registry Office, and a copy of the new survey be filed with the municipality; confirmation that all property taxes are paid up to date; that all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice; that a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. In the event that any portion of the municipally maintained and traveled road be located on either the severed or retained lands, that 10 meters from the center line of the maintained and traveled roadway, including the retained land, shall be surveyed at the owner's cost and transferred to the municipality; that a 3-meter frontage easement along Bain Avenue and a 3-meter frontage easement along Gordon Street across the entire parcel, both severed and retained lands, be registered on title to the subject property. The owner shall be responsible for all legal and survey costs. The owner applicant is also responsible for obtaining/providing a postponement to be registered on title to the subject property in favor of Greater Sudbury Hydro Incorporated's interest with respect to any and all existing charge, mortgage lien, and/or encumbrance of land registered on the title to this property. The owner will be responsible for all costs associated with obtaining said postponement, and that a deeming bylaw be passed to deem lots 37 and 38, Plan 30 to not be lots on a planned subdivision. That was a long one. So the application's a lot more simple than the conditions here. So this is in Cache Bay. It is currently a larger parcel, as you can see on this map here. The property owner is just looking to split it into 3 lots. That very long easement condition is a request from Greater Sudbury Hydro so that they have a hydro easement along the property. And then the requirement for a deeming bylaw is because you can kind of see on the underlying lines here, this retained lot has a full lot on the planned subdivision and a partial lot, which is kind of split between that and the severed 2, just to ensure that this retained lot isn't sold in separate portions. We just have to put a deeming bylaw just so that it has to stay as
one parcel.
Exactly, yeah. It's just kind of a legal procedure.
Now, severed 1 and 2 in Cache Bay, I believe there's water and sewer.
Everything's there.
That is correct, yes.
Water and sewer at the road?
Yeah.
Okay, and what's the 15 meter is 50 feet?
Yes.
50 by
It's 50.
132.
about 132. Okay. That was my only question. Any other question from the panel?
Sorry,
Go ahead.
the 15 does mean, these will be zoned as R1s?
Is this R1?
I believe this is zoned as R2.
R2?
And the 15 meets the minimum frontage requirement for R2? I don't have the zoning bylaw.
Yes.
Yes.
Okay, thank you.
Any other questions? Oh,
Yeah. Through you, Mr. Chair.
Go
There was
ahead.
a comment in the comment section of the agenda in regards to topography and drainage, I believe. Can you share the concerns there? Lot grading is a potential issue. Topography.
Go ahead, Don.
Every lot construction has to have a lot grading plan before you get a building permit. That's why there's topography shown on our sketch, so that's why he made that lot so big, so it would get away from the bank of Gordon. If you ever gone down there,
Yeah.
this is beside the Capin Jolie. What is that called again?
The Olden Age Club.
Golden.
Golden Age Club, and it's really high, and all of this stuff is being. Oh, you want me to stop?
No,
No, no.
I
She was
was
going downhill.
Okay.
That
I
was-
can tell. I was,
Yep.
yeah, all the topography's there. This is the reason why he went down to the 50-meter lots, because he had the 3 lots there before. He's changed the configuration to be able to fit better that 3rd big lot
Okay,
without going into the bank. Sorry.
yeah,
Okay,
just
thank you.
through our planner, through you, Mr. Chair, because it's just that it was a concern identified by our Public Works Department. You know how these go. Most of them, no comment, no comment, no comment. So I just wanted some clarification as to whether there's any concern from our planner on that.
Go ahead.
Mr. Chair, the reason for this comment is because because the servicing doesn't fully loop through there. So there is kind of a portion at that corner where the services are not available in the road. So again, by extending that retained land to be wider, there should be a way to configure that. If there is a concern with that, we can put a condition that they demonstrate the ability to meet the topography requirements or the servicing requirements. But that would also potentially be a bit redundant because they would have to do that at the building permit stage anyways.
Yes.
So, but that is an option.
Yeah, because they will need a lot grading plan and make sure everything is on a positive
Exactly, yeah.
drainage.
Okay, no, that's perfect. I just wanted to make sure I had clarification on that comment from Public Works. Thank you.
Thank you. Do we have any more questions? Hearing none, I'll bring it to a vote. Anybody in favor? Carried. Okay, number 4, C32/25, Macanine La Montagne.
It is moved by Jonathan Sanford and seconded by Ralph St. Louis. Be it resolved that the consent application for the creation of a right-of-way at 85 Pine Ridge Road, Municipality of West Nipissing, is approved on the following conditions: that a reference plan be prepared and deposited in the Land Registry Office, and a copy of the new survey be filed with the municipality, confirmation that all property taxes are paid up to date, that all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice, and that a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. So this is an application for a right-of-way. The municipally maintained road ends right at this property, so they're just looking to do a right-of-way through this property. It's a little funky going through the middle, but when you see the aerial, that is kind of where the functional road is there, just to provide this 87 Pine Ridge with legal access to the property.
Perfect. Because basically the road is there now.
Yes,
You just
so
legally, you're just cleaning it up.
Legalizing it,
Yeah.
yes.
Okay. Problem. Any questions? Oh, go ahead, ma'am. Your name and address, please.
My name's Jeanette Cote. I'm the owner of 75 Pine Ridge Drive, which is lot 5. So I'm not quite sure I understand what the right of way is, because in 2019, we sold a right of way to the La Montagnes through our property, because the road ends before our property. So we gave them permission to go through. And then last year, lot 7 was sold at auction. That property owner wasn't informed that he didn't have road access to his property. Fast forward, we're good neighbors, you know, we want to give everybody a right, but I don't understand this application, because how can we give right away to lot 6 when he first has to go through my property, lot 5?
Because yours is already registered. Correct, Paul?
But it's registered to the owner of lot 6, not to the owner of lot 7.
Okay.
We're legalizing what we can, and I believe there's actually another owner beyond as well. So there may be a subsequent application over lot 7 also, but the owner can still come and, like whoever needs the access can still come and negotiate a right of way with this lady here. And I'm sorry, I forget names quickly.
Jeanette Cote.
Sorry, Jeanette.
That's okay.
Yeah, or Ms. Cote, sorry. But yeah, if the owners also need that assurance of a registered right of way for that, then they would approach Ms. Cote about acquiring that. The survey is already done. There's already a part on a reference plan, but because it's an interest in land, it would need to come back before this committee as well. Now, there is the Road Access Act in the province too that guarantees that if there's vehicular access to a property now, it cannot be cut off without a judge's order first being obtained, or vice versa. It applies to both sides. But when you go to sell your land, it's not something you can really rely upon. And so a registered right-of-way provides much greater assurance. Because it's registered on title, it runs with the land, not with the property owner. So right now, we're trying to legalize the lot that we can, and the owner of lot 6 is agreeable to provide that registered right-of-way. It is something we'll make them aware of, so should they wish to approach Ms. Cote, then perhaps, and if she's agreeable and they come to terms on it, then hopefully we'll see you back here next month, or the month after, or whatever. But they still, like I say, under the Road Access Act, you cannot deny someone vehicular access to the property if it currently exists. But it's a piece of legislation that comes down to the fact situation, and it's a court decision. And I can't say that it guarantees lot 7 and access across, Ms. Cote's property, but, you know, in the absence of a registered right-of-way, that's really the only thing that the property can try to rely upon. So, yeah, but it's always better to have a registered right-of-way. And we always advise our clients that if you have the opportunity, it's by far the better way to go.
Does that answer your question, Madam Cote?
Yeah, I just wanted to express a concern, like we're not here to stop the right of way.
You can always call them to, you know, because they've done yours and the one after. The consultant would be you know, able to provide you with all the info you need.
My other questions regarding the right of way is, it's our understanding that the Lamontaines are selling plot 6 or lot 6, or getting prepared to sell that. And again, does the right of way that we've sold to them get sold with the property?
If it's
Yes.
registered on title, yes, it'll run with the land.
Okay.
And that's the whole point of registering them on title and coming before this committee to get the approval for the initial creation of it. Because otherwise, if it's just an agreement between you and I,
Right,
if I sell to Sam, then you can say to Sam, no, the deal's off. It's
right.
only between me and Paul.
It just feels a little bit suspicious that we're giving a right of way, but how's he getting from lot 4 to lot 6 without, like, I feel like if we grant the right of way to lot 6, that just automatically allows them to go through my property?
No, they still.
Because that's what I'm hearing.
It doesn't any more so than what it does right now. So like I said, we're trying to legalize the lot that we can. And if Lamontaines are selling, that was probably the impetus for the owner of lot 7 or the next lot down to approach them at the time.
Yeah,
Because, you know, if you have a neighbor that's willing to do it, then it's better to do it while you know the people.
of course, and,
And then
Right.
and like I say, then it runs with the land, not with the individual, because who knows who the next purchaser would be and what their thoughts were. And nobody wants to get into a court application to try to, you know, enforce their right to travel on the land. It's way more costly than to simply make a severance application, come to an agreement.
right,
And so, you know, we'll advise both the Lamontaines and the purchaser of the right of way for lot 7 that, you know, that they really should discuss it with you. But what we're doing today won't necessarily guarantee them access on your land. That's still your land. But there is legislation that.
yeah, like I find it hard to
you're aware
believe
of.
if you grant it through 6 that it's just an automatic.
It's-
Because how can they jump from, you know, how can they jump over the acre?
Well, and it's not an automatic, and in fact, the lawyer, so if lot 7 was to sell in the future, the purchaser's lawyer would search title and would say, okay, you've got guaranteed access across 6, but you don't have guaranteed access across lot 5.
Right.
So you still want to follow through with the purchase of the land.
I mean, ideally, that's what should have happened when lot 7 was purchased last year, but that person bought thinking that that dirt road goes straight to his cottage, and he was mistaken.
Yes, yeah, and that's why they're trying to at least resolve the lot they can right now.
Okay, can we,
Yeah, we can do this now.
yeah, you can talk all night if you want.
Yeah.
Sam, you had your hand up?
I was just gonna briefly add the fact that when I believe it's 87 Pine Ridge was put on a tax sale, it was identified in that kind of overview info sheet that there wasn't a registered, publicly owned, maintained access to the property.
Okay.
I'd have to pull up the thing to see the exact wording of what it was, but I do know there was something saying that there wasn't a publicly maintained access that was to the property.
Okay.
Okay, Don, you still have something to add? You're good? All right. All right, any more questions? Hearing none, I'll bring it to vote. Anybody in favor? Carried. Okay, we're moving to number 5. C33/25 SVK Completion Solutions.
Okay, it is moved by Kathleen Rochon and seconded by Roxanne Louis. Be it resolved, the consent application for a lot addition to 511 Peacat Road to 1354 Betty Road, Municipality of West Nipissing is approved on the following conditions. That a reference plan be prepared and deposited in the Land Registry Office and a copy of the new survey be filed with the municipality. Confirmation that all property taxes are paid up to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice. That a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. The municipal clerk shall, pursuant to Section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for drainage maintenance among the parts into which the land is being divided, and that a PIN and consolidation be registered in the Land Registry Office in order to consolidate the lot addition lands with the lands to which they are being added. So through you, Mr. Chair, I'll just pull up my screen here. This is the application that we're looking at currently. So the pink color is your retained, the orange is the land that's being transferred to this green portion here. So the proposed lot addition area is approximately 40 hectares. The retained portion, that pink strip, is just about 3 hectares. It does have the minimum 61 meters of frontage. And the lands that are being added to is to a property which does front onto Betty Road. I will leave it at that.
Thank you. Any questions from our panel? No? Any questions from our audience? Okay, hearing none, I'll bring it to a vote. Anybody in favor? Carried. Number 6, C34/25, Allison Black.
It is moved by Jonathan Sandiford and seconded by Roxanne Louis. Be it resolved that the consent application for the creation of 2 new lots at 1354 Betty Road, Municipality of West Nipissing, is approved on the following conditions. That a reference plan be prepared and deposited in the Land Registry Office and a copy of the new survey be filed with the municipality. Confirmation that all property taxes are paid to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice. That the transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. In the event that any portion of a municipally maintained and traveled road be located on either the severed or retained lands, that 10 meters from the center line of the maintained and traveled roadway, including the retained lands, shall be surveyed and transferred to the municipality. And that the municipal clerk shall, pursuant to Section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for drain maintenance among the parts into which the lands are being divided. So the lands that we just added to are now the subject of the application. So where the lands front onto Betty Road, they're looking to take 2 parcels out. Each has a minimum lot area of 4 hectares and about 76 meters of frontage. The retained is already at 94 hectares, but we'll be getting some more, and does have the minimum lot frontage requirements as well.
Thank you. Any questions from our panel? No? Any questions from the audience? Now, I do recall that this land was more of bush area. Just want to make sure.
Sorry,
Can you bring it up, please?
Yep.
Right at the end there, right?
Yeah, so the area where they're looking to sever is right kind of around there.
Okay. Thank you. Any questions? No? Hearing none, I'll bring it to a vote. Everybody in favor? Carried. Move on to number 7, C26/25, Brian Snell.
Alrighty, it is moved by Kathleen Rochon and seconded by Roxanne Louis. Be it resolved that the consent application for the creation of 3 new lots at Betty Road, Municipality of West Nipissing, is approved on the following conditions. That a reference plan be prepared and deposited in the Land Registry Office and a copy of the new survey be filed with the municipality. Confirmation that all property taxes are paid to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice. That a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. In the event that any portion of a municipally maintained and traveled road be located on either the severed or retained lands, that 10 meters from the center line of the maintained and traveled roadway, including the retained lands, be surveyed and transferred to the municipality, that the municipal clerk shall, pursuant to section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for drain maintenance among the parts into which are being divided, and that consent application file number C27/25 be approved. Through Mr. Chair, this is an application that was seen at the previous meeting. The applicant is looking to, sorry, Madam Mayor.
Sorry, I would prefer if we spoke about the lot addition application first, because without approval on the lot addition, this whole discussion then becomes moot, because in order for this application to proceed, the lot addition has to be approved. Is that correct? It just seems like backwards. So we could have this discussion, but then again, without doing if we don't discuss the lot addition or approve or whatever the lot addition first, then the specifics of this application are no longer relevant.
So,
Which one is,
Mr. Chair, if you'd like, C27 is that lot addition. I can read that resolution as well right now. If you'd like.
go ahead.
Okay, thank you. It is moved by Ross St. Louis and seconded by Jonathan Sanford. Be it resolved that the consent application for a lot addition at Betty Road, Municipality of West Nipissing, is approved on the following conditions: that a reference plan be prepared and deposited in the Land Registry Office, and a copy of the survey be filed with the municipality. Confirmation that all property taxes are paid to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice. That a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. That the municipal clerk shall, pursuant to section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for drainage maintenance among the parts into which the lands are being divided, and that a PIN consolidation be registered in the Land Registry Office in order to consolidate the lot addition lands to the lands to which they are being added to. So, the application before you, let me just scroll to the other image here. So the lot addition that's proposed, you can see on your screen here. So it's an area of just over 3.5 hectares that's being added to the lands immediately to the east of it. The reason that this lot addition being approved is a condition of the resolution I read before, is because when you take out these 3 lots that are proposed, as it stands without that lot addition, they do not have sufficient frontage for the retained. So by doing this lot addition, they can ensure that they have sufficient frontage for the retained. And I will say that these applications were referred to the Agricultural Advisory Committee at our last meeting. So for the lot, sorry, so now I'll let it word here. For the lot addition, the committee was not supportive of the application due to the fact of the location of the municipal drain, the fact that there's no easement registered and that the property is tiled. And then for the severances itself, the committee was also not in favor, given the fact that the property is actually farmed, it is tiled, and it is a prime agricultural land, although it's not defined in the official plan as prime agricultural.
Okay, thank you. Do we have any questions from our panel? So are we doing, I guess, C27 first?
Yes, and just procedurally as well, if I could.
Yeah.
Recognizing the request previously mentioned about being 3 separate applications, hearing the decision on each one, because you have a resolution on the floor that was brought back from previously being referred, that is the motion that we have to go with. If there's any interest in amending, reducing, changing the size, that sort of thing, we would need to have a motion to amend the resolution. We'd have to go through that discussion. If that passes, then we would discuss the resolution as amended, instead of going through 3 separate yes, yes, no sort of thing. Yeah.
Okay, so we're going to vote on the addition first?
Yes, if we could.
On 20. Okay, through you, Mr. Chair. I'd like to say that I did attend the Agricultural Advisory Committee meeting in regards to this application. And the concern was any movement of that lot line, whether to the east or to the west, would have impact on the drainage on both of those both of the properties, the one that we're discussing and the neighboring property to the west. And, you know, like because of how everything drains there. So I just would like to share just, you know, what was discussed at that meeting from the Ag Committee. Thank you. Thank you.
I'm a little concerned, lost here. We're asking questions on C-27?
Yes,
Or
C-27,
C-26?
C-27, which is the lot addition.
Okay. Any other questions from our panel? We're doing the lot addition, C-27. No? Any questions from our audience, Madame Baudry?
Once again, I'm going to mention that your present OP, since that's what we're working on, is 2+ retained, not 3. When it comes to municipal drains, there is the Municipal Act that you need to follow, the Municipal Drainage Act that you need to follow, and I don't know how this is affected by that. So of course, the Federation would ask that you defeat this motion for the addition, keep all this land in production. The other thing is keep down the traffic on that road, because we do know that slow-moving equipment is going further down the road too far.
Thank you. Paul, you had the...
Sure. Thank you. I believe there's only one farm south of the road, further down the road. Once you get to the left side of the page, as shown, it becomes pretty much bushland from there until you get the open fields down at Allison Locks and Sam Collins or SVK's previous application. I did go out immediately prior to the ag meeting and confirm that the municipal drain is basically located right down the original property line of the two properties. I know it was brought up at the ag committee meeting as well, that there is a minimum lot size considered for an agricultural lot. And if I remember correctly, I believe it was established at 30 hectares, which would be approximately 75 acres. The original lot size for this easterly lot is approximately 30 to 35 acres, so a little less than half of what would constitute a farm lot. But we did concede at the ag meeting that because of the location of the municipal drain, that we wouldn't contest their recommendation that the lot addition be denied. Do you want me to make just a couple of quick comments about the other as well? So technically, even if all 3 lots were applied, we still have frontage on the retained because the frontage technically is on the river, but access to it over that thin little narrow strip, you probably wouldn't be able to drive down it, but you know, you could hike in with your backpack to get to it. But technically, it's not a lack of frontage that would defeat it. We're also looking, and we discussed this at the Ag Committee, because now there is the impetus to only allow 2 as per the official plan. And one of the comments I was making is if we are taking a strict reading of the policies of the official plan with respect to 2 plus retained, we should also be taking a strict interpretation of the official plan that these are rural lands. These are not prime ag lands. They are not agricultural lands. These are rural lands, and my client is entitled to severances through them, or at least entitled to make the application. We do recognize it's farm field in production, and one of the recommendations we made to the committee at the time was we could reduce the footprint of these lots. They are currently 2.5 acres, 1 hectare in size. So really, we only need 1 acre of land to support the home, a septic and a well, especially with only 2 of them side by side. So my client would be willing to reduce the size of the lots to preserve as much of the field as possible. But that's whereas Samantha was saying, we would need a resolution to change the resolution. So we also throw that out on the table, that if there's, I think it's a great compromise situation. We preserve as much of the tiled farm field as we can. We still allow the property owner on a lot that would not be considered a full agricultural lot, would not be considered a full farm lot. And then the only reason this would be any different than if these were two separate owners of the side-by-side lands, one's in the wife's, or one's in a husband's name, one in the husband and wife, they checkerboarded it. But if these were two independent property owners, essentially that easterly lot would not be considered a viable farm lot, a viable agricultural lot. But we're still being what it is, with the ownership what it is. The compromise is, let's reduce the area, let's still grant the two in the corner. And there's already an awful lot of development along Betty Road. Some of the nicest homes in Verner are located along that road. There's a lot of residential development already along that road. Yes, there's 2 or 3 farms that are actively still in production, but for the most part, this is a residential neighborhood, especially the ones backing onto the river. And maybe that's why it wasn't included as part of the ag lands in the first place. Anyway, that would be my contention and proposal to the committee. We would need a minor variance for the reduction in the size of the lot, and if approved, it would have to be conditional upon the minor variance.
And you,
If I can.
yeah, go ahead.
Correct me if I'm wrong, however, what we'd be looking at is C27 is defeated and you're conceding that we're not gonna add that. I would like to make a motion then that for C26, and I totally understand, the gentleman came the last meeting and basically told us that the official plan says only 2 severance, not 3. They're right. And if we're going to follow our official plan, we're going to follow the official plan. Right now, the official plan, unfortunately, or not fortunately or unfortunately, take it as you will, states that that is not agricultural land, it's rural, and the individual may sever 2 sections. So, and if the individual is willing to work with the municipality and the agricultural community and go from 1 hectare to 1 acre, I would put a motion that we go to 2 severed lands and 1 retained and 1 hectare, or 1 acre each.
Any more questions?
Hold on.
Sorry.
Okay.
now that We have a motion on the floor.
Okay, so we-
have a mover and we need a seconder.
Okay, do I have a mover?
I move.
I'll second it, but I would actually prefer, I'll second the motion, but I will say I would actually prefer to deal with the lot addition and then have it come back properly drawn up for us to like, I don't want to approve something when we don't have the plans here in front of us. And so I would actually prefer to have a motion to defer to allow the consultants on that recommendation of minor variance to minimize the lot sizes down to 2. So we're actually voting on something that we can see instead of, do you know what I mean?
Yeah, not a problem.
That's my preference. And so I would second Rock's motion. I don't know that I prefer to support it, to see it adjusted.
Okay.
I don't know.
Can we get a motion on C27? So the lot addition.
And deal with that. So if the committee wishes to vote on C27, and then we can put that one to rest. And then we can come back to see whatever, and then look at amendments or deferral, whichever the committee wants to follow.
Okay. So now we're dealing with C27.
Yes, the lot addition.
Okay, we're gonna vote for the lot addition. If, I'll bring it to a vote. Anybody in favor of the lot addition? Defeated.
Thank you. So now we're back with C26,
26.
and we have an amended motion on the floor to approve the creation of 2 new lots, each being 0.4 hectare, 1 acre in size. That's the motion for discussion.
Yeah, but the motion, then it has to come back, what Kathleen was saying, it comes back redrawn?
Well, the recommendation that we redraw it, I don't think there's any secret in what it will look like. Rather than being a rectangle, it's going to be a square with a line drawn basically right on the same plan where the 1 and 1 hectare is. That would be essentially what we're looking at. I know not everyone can see this, but we would just be moving that north line south by, 60% of the lot depth would then give us the 1 acre. So I don't.
That's gone and that goes down.
Yeah, and severed 3.
So,
Yeah, severed 1 would be off the table. We're only looking at severed 2 and 3. And the line would be dramatically, would be reduced by 60% of the line. So that each of the 2 lots created would basically be an exact square, 61 by 61, which would be, it's probably a little more than the 61, but would be 0.4 of a hectare, 1 acre in size.
If I,
As a point of procedure, we can't approve that without the minor variance actually coming to the committee to be approved, because the reduction in the lot size is a minor variance itself. So it's still going to have to come back to the next meeting as a minor variance. Correct? Like we can't, in principle, we approve it, but really nothing could be approved and nothing can be completed until because
Yeah, I understand.
approved.
It would give some assurance to my client though to proceed with the minor variance if it was approved subject to and if the minor variance is defeated, we can't follow through with the severance approval.
Correct. Would the panel be okay with subject to the minor variance? It's like he's, like Paul is saying, because if not, there's no use coming back with a minor variance. Depends on the panel. Everybody in favor? Carried. So we'll go,
may,
yeah.
can I now read the resolution as amended, just to make sure we're all on the same page?
Yeah.
with everything?
Gets
Hold on.
confusing.
Don, guess.
Okay, Don, go.
Just a quick question, is that 2 minor variances we have to apply for?
It'd be 1 minor variance for the 2 lots?
We can do this
No.
one up.
No, it'd be one minor variance because until the severances are perfected, you're still only dealing with 1 parcel of land. So we're reducing the minimum size down to 1 acre for that piece of land, and then we're taking 2 1-acre pieces off in accordance with the minor variance. Sorry, I'm not trying to get out of the extra 750, but my client's already paid a lot towards these as it is, so.
Well, I was just making a comment on the application wise. Because if it's 2 lots, and like you guys are saying that we have to put in for each lot individual to make them 1 application, this is kind of the same thing. The way Paul is saying it is that we do the minor variance first and then the severance comes through. And I'm not asking for the client to pay more money. I just want resolution on how we're going to do this.
So what would be, I'm asking the panel, what would be, or you, Samantha, what would be the ideal way to do that?
Right, so the proposal, from my understanding, is to make the minor variance a condition of the application. So they'd have to get that minor variance before the lots are created. So at that time, it would be 1 lot. That can be something that I can also take away in the next month before that minor variance comes back to just confirm if it should be as two separate applications.
Good.
Understand?
Clear as mud.
So may I?
Yeah, it's clear as
read
mud.
the-
Go ahead.
Okay. So it is moved by Kathleen Rashad and seconded by Roxanne Louis. Be it resolved that the consent application made by Brian Snell for the creation of 2 new lots at Betty Road, Municipality of West Nipissing is approved on the following conditions. That a reference plan be prepared and deposited in the Land Registry Office and a copy of the new survey be filed with the municipality. Confirmation that all property taxes are paid to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice. That a transfer be submitted to the secretary for the issuance of a certificate of consent. In the event that any portion of the municipally maintained and traveled road is located on either the severed or retained, that 10 meters from the center line of the maintained or traveled road shall be surveyed at the owner's cost and transferred to the municipality. The municipal clerk shall, pursuant to Section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for drain maintenance among the parts into which the lands are being divided, and that the applicant provides that a future minor variance application to reduce the minimum lot area from 1 hectare to 0.4 hectare be approved. Does that work?
Makes sense? Makes sense to me. Clear as mud. We're all good? I call it to a vote. Everybody in favor on that motion? Carried.
Okay. Okay, last one.
Go ahead.
All right. It is moved by Jonathan Sanford and seconded by Roxanne Louis. Be it resolved that the consent application for the creation of new lots at Betty Road and Phuket Road, Municipality of West Nipissing, is approved on the following conditions. That a reference plan be prepared and deposited within the Land Registry Office and a copy be provided to the municipality. Confirmation that all property taxes are paid to date. That all conditions be met on or before July 4th, 2027, being 2 years from the date of giving notice. That a transfer be submitted to the Secretary Treasurer for the issuance of a certificate of consent. In the event that any portion of a municipally maintained and traveled road be located on either the severed or retained lands, that 10 meters from center line of the maintained and traveled road, including the retained, shall be surveyed and transferred to the municipality. That the municipal clerk shall, pursuant to Section 65(1) of the Drainage Act, instruct the municipal engineer to apportion the assessment for drain maintenance among the parts into which the land is being divided. So this is an application just on the other side, the south side of the road here. So I'm just pulling up the sketch for us. So this is the application being brought forward. The proposal is to do a one lot out of the Betty Road side, which contains the dwelling and some of the outbuildings, and then to create 2 lots fronting onto Phuket Road. The proposed onto Phuket Road each is 1 hectare, and this is a rock outcropping that's a vacant area. This application was also brought to the Agricultural Advisory Committee. Their recommendation was the application be approved on so for the surplus dwelling, and then for 1 2-hectare size lot out of the Phuket Road side of the property.
So one and not 2.
Yes, and we
Correct.
do also have a letter from Madeline Beaudry with the Federation of Agricultural identifying some concerns with the configuration of that surplus dwelling and the associated outbuildings, and I'm sure that she will be able to speak to it more if she wishes, but I will leave it at that.
Okay. Any questions from our panel? No? Okay, go ahead, Kathleen.
Thank you. I have read the submission from the OFA, and I do agree. If there was a way that the house and garage could be severed while leaving behind all of the farm operating buildings, that would be a far more ideal circumstance than what has been proposed in the drawing, because the drawing as we see it, even though it is being purported that the manure pond is dry. It looked like the line that they were proposing kind of goes through the old manure line and takes into account buildings that have agricultural purpose that don't really have a purpose in a residential setting. So I would be supportive of an application. Again, similar to what we just did, I would have no problem in actually reducing the minimum lot size through a minor variance to something that would encompass the land that the house and the garage is on, while leaving all of the farm buildings and the manure pond intact as part of the retained.
And no, it's a point well taken by both of the written as well as the mayor's comments. The one issue I have though, if we leave the barn and the manure pond with the farm, there's no way we can meet the minimum distance separation formulas because we're right next door. Now, this, there's nothing precluding this lot from being sold together with the farm property in the future. The house is currently being rented out. My client does wish to sell off the house, but if he gets an offer to sell the house and the farm together, he's a businessman, he's a farmer himself as well, as farms in the south, also is leasing out these lands for agricultural production. He understands that, but he doesn't want to be in the business of being a landlord on this property. And so if someone approached him with an offer to buy both the house and the farm together, then of course there's nothing wrong with them operating the barn and the manure pond with the farm operation. But if we sever it off so it stays only with the farm, then we have to meet the MDS calculations, and there's no way we can do that. The drive shed, my client specifically wants to keep that with the farm operation because that's where the equipment is stored to be able to work the fields. It should stay with the farm, and this is all cash crop. There's not a livestock potential. That doesn't mean in the future that there can't be a switch from cash cropping to livestock. But right now, this is all cash crop. There is no livestock operation, and therefore the barn and the former manure pond are surplus to the actual farm operation as it exists today. Even without the barn, if someone did want to switch and build a new barn, the barn is fairly old, so perhaps a new purchaser of just the farm property, they still have lots of land. This is a huge piece of property. There's no issue with them being able to build a barn and meet the minimum distance separations from any of the residential uses nearby. So for those reasons, that's why we kept the barn with the house property.
Thank you. Omer?
Yes, I just want to comment, yes, it's a cash crop, but if we put in the building over there, what's a livestock farmer would come and buy that building? He's not going to have the property to farm. He's not going to have the property to put livestock and nothing. And in the future, I know I see it coming. There's more and more of the hobby farming coming that they need property. And by removing the property of the house, we are forcing people again to build a new barn, to build a new house. If an individual like you buys the property, just the land, now you're forcing him to build in the prime land over there where it's cash crop. We're losing our land.
Thank you.
We're not forcing them to build in the fields. There's a lot of bushland on these lots as well. So that is a decision for the farmer. If he wants to keep as much land in agricultural production, he has that opportunity to do so on this particular property.
Okay. Any more questions?
No, for me, I think our decision at the last meeting was to send us to the Ag Committee, and we did. And the Ag Committee says to move forward with amendments, whatever the amendments are. My opinion is to move forward to take the information that we received from the agricultural committee. And basically, like we say at our municipal meeting, we sent it to the expert. They made their determination. They approved it with the amendments, and I would support that.
Okay, so go ahead, Samantha.
My apologies. If that is your request, can I ask you to make a formal motion and then have a seconder to amend the resolution to align with what the Agricultural Advisory Committee provided?
I will make a motion to move forward with this resolution as per the agricultural committee's recommendation.
Do I get a seconder?
Sorry.
Jonathan? Okay, we're good?
Yep.
Any more questions? Madame Baudry, something different?
Once again, I ask you to look carefully at the document that was provided with you and keep farm buildings with the farmland.
Thank you. Okay, I'll bring, go ahead,
Hey,
Kathleen.
Is there a way to do the severance in such a way that that's being requested, or does MDS get in the way? Like, is there an amendment that can be made that is a happy medium there somewhere? Like, I kind of understand the MDS, but can it be done, or can it just not be done? Then question would be to our planner, please. Through you.
Okay, go ahead. Do you know that?
Well, I know the answer, but I'm not your planner.
Oh,
But I could give you the answer to my client.
Sorry, I'd just like the answer from our municipal staff, please, if I could.
okay, go ahead.
Yes, through Mr. Chair, it is something we could look at. I do believe that all the options have really been considered here, and there has been a consideration of what the MDS implications are. I'm not sure if Paul is aware of any alternatives, but I do think when you start shifting those agricultural buildings, and especially that manure pond, onto that farm structure, we will have some MDS complex.
Does that answer your question, Kathleen?
Yeah, so I guess one other question in Madame Baudry's submission, she also mentioned or not, like, again, the line looked like it was going through the middle of the manure pond, so that half of the manure pond would be on the retained and half would be on the house or the residential lot. Has there been any kind of examination of that pond for any kind of environmental concerns?
At this point, no. At this point, no. There's currently a well with the house and a septic system with the house. I don't know of any concerns with respect to the water. It's not being currently used as a manure pond. Splitting the line, we can adjust at the time of doing the field survey that we incorporate all of the manure pond with the severed lot, if that's a concern. But even taking off whatever it is, 30-40% of the manure pond means that it's no longer viable as a manure pond because you can't fill up just to that line and then make the liquid manure stop. So it does effectively decommission that manure pond as a manure pond, whether it's wholly contained within the severed land or partially. If there were concerns with respect to environmental issues, then the house probably wouldn't have been able to be rented out or be habitable if they did not have potable water. So there's never been a concern raised in the past, and now that the pond has been decommissioned, I don't know why there would be one in the future. And I believe your official plan does state that you must comply with the MDS calculations. I've argued about that because when they were initially brought in, they were brought in as guidelines, but then in municipality's official plans, they got basically written into stone that they must be complied with. So
Okay.
that's the other part of it.
Thank you. Lavelle?
Yeah, my concern again, by dividing that pond, if you decide to sell, if a new owner, a new farmer comes and with the house and the building and the barn and he wants to do a feedlot with the barn, well, he doesn't have the full access to the pond because it's been divided, because he doesn't have property.
Yeah, but if-
That is manure. He'll
The
be
pond,
stuck.
the pond has been decommissioned.
But they could be used if a new farmer wants to put a feed lot in there and the barn he could still use, but now we're putting a line right across, it won't be big enough. He's gonna have to apply to put a bigger one because he doesn't have property to put his manure.
Thank you. So we're sticking,
So the resolution on the floor currently is to approve the application as amended by the Agricultural Advisory Committee. So that would be to create the one new lot pulling the surplus dwelling out, and then for one new lot with an area of 2 hectares fronting onto Piquet.
yes. Everybody, I can call it to a vote. Hey, everybody in favor? Defeated. So we're done?
Yep, so it is moved by Kathleen Rashawn and seconded by Roxanne Louis. Be it resolved that the Committee of Adjustment meeting held on July 3rd, 2025 be adjourned tentatively to August 7th. And I will let you know closer to the date if a meeting will be occurring.
Thank you.
Yeah.
Thank you, everybody.